The Wills and Trusts question from February of 1999 almost qualifies as a Wills and Trusts remedies question. If you don't know what I mean, you'll see as we get into the analysis. Let's take a look at the rather awkward call of the question. In 1998, Sis died insolvent. Carl and Dan then sued Buddy as surviving trustee, asserting that 1. Based on Wanda's promise never to revoke her 1990 will, the trust should be terminated. And 2. Buddy should be ordered personally to repay the total of $1 million in trust income, which Sis had distributed from the trust to Abby's sons. How should the court rule on each of these assertions? Discuss, answer according to California law. Well, obviously we're dealing with wills and trusts in this fact pattern, but honestly, we can't do a great deal of organization based on the call of the question. So, we think a little bit about our mental checklists for wills and trusts, and mindful that the first step for both of these is establishing the validity of a testamentary document, we read the fact pattern. So, please turn with me to the top of the fact pattern. In 1990, Harry and Wanda, husband and wife, properly executed wills, each stating, then we have quoted language. While signing the wills in the presence of Wanda's siblings, Sis and Buddy, Harry and Wanda orally promised never to revoke the 1990 wills. Okay, stop right there. If the first call of the question is asking if this trust should be terminated based on an oral promise never to revoke the will, the answer is no, because oral promises about wills fall under the statute of frauds. They aren't valid unless they're in writing. Let's read on. In the following paragraph, Harry dies in 1991. He is survived by Wanda and Abby, Carl, and Dan, all children of Harry and Fran. Abby died in 1992 while visiting Wanda and was survived by Abby's 3 young sons. Well, anytime we start learning about all these survival statistics, we have to start thinking about lapse and anti-lapse. As we'll see, other questions cover those issues a lot more thoroughly than this one does. Next, we learn about the events of 1995. Wanda is angry with Harry's surviving children. She revokes her 1990 will and signs a new one, and she has the authority to do it. Her new will leaves all of her property to Sis and Buddy as trustees of a trust for the children of Harry and Fran, to last until the death of the last surviving child of Harry and Fran. The trustees given total control over distribution of income to trust beneficiaries prior to the trust's termination. Wanda dies in 1996, and it doesn't look as if there is anything wrong with the language of this trust. It also appears to give the trustees virtually unfettered discretion, so long as they don't violate their fiduciary obligations. Next, after Sis and Buddy accept jobs as trustees, Buddy lets Sis handle everything. So, to the extent Sis engages in misconduct, Buddy is jointly and severally liable. For the next 3 years, Sis distributed all trust income to Abby's 3 young sons. Well, what's wrong with that? As we're going to conclude, nothing is wrong with that. Next, we get the call of the question. Sis dies insolvent in 98. Carl and Dan sue Buddy as surviving trustee, as they have every right to do. Sadly for them, their claims are not going to go very far. So, without dwelling on the call of the question again, please turn your attention to the outline of issues that I've presented. I think you'll find that the organization that I select is both intuitively understandable and also easy in terms of actually writing an answer around it. So let's have a look. First, we examine Carl and Dan's efforts to terminate this trust. We have to go through the chronology of events, and we have to focus on the validity of the various documents. So, first, we examine Wanda's 1995 will. It's valid. Next, we go into a discussion of Wanda's promise never to revoke this 1990 will. It is unenforceable. Then we focus on the testamentary trust established in the 1995 will, and that is valid also. Then we focus on Sis's distribution of $1 million to Abby's sons. Wanda granted total discretion to the trustees. It looks as if her distribution of trust income to Abby's sons is proper. And to the extent that Sis is found to have done anything wrong, Buddy will be liable for that. As we'll see when we get to my answer, I acknowledge that it might be a close call and that reasonable people might differ. Still, I conclude that the trust has been validly created and that Sis's actions as trustee are reasonable. Then we focus on the second call of the question, the far less elaborate one, Carl and Dan seeking to get Buddy to be ordered to repay the $1 million that was paid out to Abby's sons by Sis. Okay, well, let's explain it carefully. The first step of the analysis is to get on the table clearly that Buddy was a co-trustee of Sis as trustees of Wanda's testamentary trust. And Buddy, like Sis, owed the trust and the beneficiaries duties of loyalty and care. Ultimately, I conclude that Sis lived up to her obligations and, therefore, the plaintiffs, Carl and Dan, will not be able to obtain any remedies against Buddy. Now, before we review the answer in some depth, let me acknowledge, once again, that this is a classic example of a fact pattern that had more than one acceptable conclusion. It is, I think, pretty hard to argue against the validity of the 1995 will and the testamentary trust. And, respectfully, I think anybody who did so argue was wrong on the black letter law. Well, once again, the Committee of Bar Examiners was not really looking for the correct answer. Plenty of successful candidates actually got it wrong and still were successful. So our answer will present a consistent analysis. And I think you'll agree that the answer I present is the majority answer. It is correct. But once again, the examiners are looking for technique ahead of substance. They are looking for analysis ahead of a conclusion. And in at least one significant respect, this is a fact pattern that is testing a gray area where reasonable people could interpret the facts differently. So now let's turn to the answer and have a brief look at it. First, we examine Carl and Dan's effort to terminate this trust. I lead with the facts. I explain who Carl and Dan are, and I indicate that their first argument is against the validity of the trust. And we discuss their efforts to terminate it. Now, just as indicated in the outline, I follow the chronology. Now, before we review this part of the answer, let's just pause for a moment. Here again, I want to make a specific comment about an alternate method of organization that was entirely acceptable. I start off with the 1995 will. That's because this is the document that contains the trust that the plaintiffs Carl and Dan are seeking to terminate. Another absolutely reasonable way to do this would be to start off with the 1990 will and proceed accordingly. That might make more intuitive sense to some of you because it is more of a straight chronology, rather than my approach, which is to take it somewhat out of order. So either way is acceptable. What we're looking for is thorough, reasonable analysis. There is no magic key. We're just trying to unlock this problem as best we can. Okay, fair enough. Now, look at 1A, the argument about Wanda's 1995 will. Here again, I lead with the facts, and I think you'll see that my analysis in this second paragraph of the answer is very solid and well worth your study and review. Notice, I focus on her capacity, which is not really at issue. Her intent also is clear, and I focus right up front in this second paragraph on the fact that the testator is angry with the two guys that turn out to be our plaintiffs, Carl and Dan. That's the entire reason why she revoked her 1990 will and created a new will in 1995. We don't have details about the formalities of the 1995 will, but we've got no reason to think that it was invalid for any reason. Next, I focus on what many of you may have considered first, her oral promise not to revoke the 1990 will, and perhaps the underlying validity of that document. But I focus on it here, and to me, the key issue is the statute of frauds. It's far more commonly tested in contracts than here in wills and trusts, but it is in every outline on the subject that you'll see if you look carefully enough. Next, I focus on the testamentary trust established in the 1995 will, and here again I lead with the facts, and then I go into the details about what the law is. Look at the second paragraph in this section. Here, I actually get a fair amount of law into the answer. I explain the requirements for a valid trust. We've got to have a writing, a corpus, a valid purpose, one or more trustees, and beneficiaries. Then, I focus on the facts that show each of these elements has been satisfied. Then, I consider also the power given to the trustees. They have total discretion, and that provision also is valid. And then I reiterate the point that Wanda is angry with Carl and Dan, and she had the power to set up a discretionary trust with strong trustees. So, I conclude that the 1995 will is valid. Her 1990 oral promise not to revoke her earlier will is unenforceable, the testamentary trust is valid, and Carl and Dan lose. They can't get the court to declare this trust invalid. Now, let me pause for just a moment and make a point that I have made many times before and will make many times in the future. If you chose to organize your answer around boilerplate and, say, to lead off with a lot of law about what the law of wills and trusts is, and maybe a lot of law about what a discretionary trust is, and all of that other stuff, if you'd done all of that, you wouldn't have time to do the analysis. Now, I will never say that a statement of law is necessarily wrong in an answer, because it isn't. Plenty of answers have a lot of law that I would consider boilerplate, yet they still pass. Still, as we study answers that the bar publishes, we see that the state bar is not looking for a lot of long definitions. The state bar is looking for analysis. And so, although you've already seen a fair amount of law in this answer, mostly what I'm trying to do is analyze the facts in accordance with the legal principles, and then reach clear conclusions that are based on that analysis. So, now let's move on to the easy part of this fact pattern, the second issue about Carl and Dan seeking to get Buddy personally liable to repay $1 million. Once again, we follow the chronology of events, and we interpret them in accordance with the law. And here, I do it more or less in the exact order it was presented. I start off with Buddy and Sis being named co-trustees. These two witnessed the earlier will, and they are trustees of the testamentary trust that's created in the later will. Then I go on to establish the fiduciary obligations that Buddy and Sis jointly are operating under. Here again, I find a home for a fair amount of law explaining what these fiduciary duties are. I don't go into great depth, but I do get the details of the law out there, and then I analyze accordingly. The section under C, the distribution by Sis of $1 million to Abby's sons, is another important set of analysis in this answer, and I suggest it might well be worth your while to really pay a close bit of attention to my use of language and to my analysis of the facts. I lead with the facts under C. I explain that Sis did all the work relating to the trust, and I also state what she did with it. She distributed all of the income from the trust to the 3 young sons who survived Abby, who was one of Harry's children by Fran. I indicate that Wanda had granted total discretion to the trustees, and I suggest that this was a facially valid provision. Next, I focus on Sis's distribution of trust income to Abby's sons. And here, even I acknowledge that the conclusion that I reach is a somewhat close call. But I make my analysis grounded in the actual language of the documents. The express terms of Wanda's testamentary trust were that it was designed to benefit the children of Harry and Fran. Abby was one of these children, but she died in 1992, 3 years before Wanda executed her second will. Now I work in a little bit of lapse anti-lapse material. There's only a little bit present in this question. I've indicated that you'll see a lot more lapse and anti-lapse action in other fact patterns than you do on this one. And certainly, lapse and anti-lapse is one of the most important issues on the California Bar Wills and Trust outline for California Bar essay purposes. But here, we acknowledge that California allows for the surviving children of a deceased beneficiary in a will to take a share by right of representation. And that fact combined with the total discretion that the trustees were given by Wanda, and also taking into account the fact that Wanda was angry with Carl and Dan, it seems entirely fair to me to allow these young sons of Abby to be considered eligible to receive discretionary disbursements from this trust income. So, I say it's a close call, but I uphold the conduct of the trustee, and thus I find that Buddy is not going to be on the hook. But I don't just jump to that conclusion. Notice that I have a separate section of analysis about Buddy's potential liability. I indicate that he let his sister do all of the work as trustee, but he agreed to be co-trustee, and that means he is personally on the hook for any liability caused by mistakes of Sis. And I also indicate that Sis died insolvent in 1998. So any liability will have to come from Buddy because the estate of Sis lacks any funds to pay compensation. As I conclude, Sis is protected. She was acting within her broad discretionary authority as a trustee at the time that she made these distributions of trust income to the sons of Abby. Accordingly, Buddy doesn't face any liability. And then I add in the conclusion, in the event that a court were to reach the opposite conclusion with regard to the conduct of Sis and ruled that she did breach her fiduciary duties, in fact, Buddy would stand to be personally liable for the $1 million that Sis paid out to the sons of Abby. And that wraps up a consideration of a fairly complicated wills and trust fact pattern. It's complicated because it requires you to make a close call on factual issues in the context of civil litigation in which plaintiffs have come to court with a theory of liability arising out of the law of wills and trusts and seeking remedies.